Questo, you can go whenever you are ready.
Good morning. I'm Wendy LaQuasto of Fox & LaQuasto, here today representing David Morrow, the claimant in this workers' compensation proceeding. I would like to reserve 4 minutes for rebuttal. There's 3 issues raised in my brief. On the third issue, I'm just going to stand on the briefs. That's the attorney fee issue. On the second issue, I anticipate the court's main focus today is going to be on issue 1. So I'm just going to simply say on issue 3 that there's just no CSE to support the JCC's findings in the final order that Dr. Taylor testified he found no relevant, objective relevant medical findings when he last examined claimant.
Issue 2.
Yeah, well, that's issue 2. Yes, I'm sorry. That there's no CSE to support that finding. It's undisputed. Dr. Taylor saw this man the last time on June 10, and he found.
And he saw your client after the nurse practitioner the last time.
You probably know that from looking at the record, and I don't. I'm sorry.
Well, that's my recollection.
I just know that he saw him that day, and he found he found pain on palpitation and decreased range of motion, and those are the objective findings that's in the record on that day. And so there's just no CSE to support that he found that there were none on the last time he examined him, and that's a basis for reversal. Unless you have some other question on that, I'm going to go on to issue 1, which focuses on the denial of the claim for an orthopedic spinal surgeon or neurological evaluation as recommended by Dr. Taylor, the authorized treating physician. The EC's only defense to this claim was that there was a lack of objective relevant medical findings under 440.09 sub 1. They put all their eggs in the objective relevant medical findings basket.
Well, but if I understand what you just said about issue 2, your point, the bottom line for you is even if they're right on the statutory interpretation issue, there were objective manifestations as found by the doctor.
That's correct.
So either way, they lose.
Right. I mean, that whole theory is that they don't need them, they don't need to have these findings at each and every examination. They're there.
And so if, in fact, we found on the last visit the doctor noted in his records objective relevant medical findings, we wouldn't need to reach the first issue.
That's right. That's right. And, I have argued in my briefs that, the nurse is the one who saw him on the last time, and he's the one that said that there weren't any objective relevant medical findings. I don't think ORMF is better. I have a hard time with that. So, I think that, the case can easily be affirmed under the June 10.
You mean reversed?
Reversed. Under the June 10 findings by Dr. Taylor. But I guess I would like to be able to sit down and end my conversation at this point, but I do think that it is important to discuss the statutes, because I think that what the judge did here is clearly an error, and I think that an opinion from this court could clarify this. I see a lot of cases where they're arguing objective relevant medical findings lately, and in this situation they are using an element of proof from 440.09 sub 1 and trying to read it into 440.13.2a, which is their duty to provide medically necessary care, and under 13.3d and I, which is their duty to provide referrals, and their waiver that it arises when they fail to respond to referral from authorized treating within the time required. And I think that, although I know the court just needs to decide it on one issue, I think that an opinion that would clarify that this is a wrongful reading of the statute, that it's judicial legislation by the JCC, I think that would be helpful. I guess, I know y'all tell us that if there's no questions, that I should just say, unless you have any other questions, I'm going to sit down.
Thank you.
May it please the Court. Tom Vecchio from Lakeland on behalf of the Applee, Sam's Club, and Sedgwick CMS. Your Honors, the first concern of the employer carrier, the Applee, is the way that the claimant has structured the brief and the arguments set forth today. The appellant has characterized the argument before the Court, the issue before the Court, as a purely legal matter, yet argues facts throughout the briefs. The Court, upon review of the relatively...
Isn't the question, though, whether you need objective medical findings for an evaluation or further evaluation? Isn't that purely a legal question?
In that context, yes, it would be, Judge. If we were framing that question by itself without looking at the facts of the case, I would agree.
The second issue is purely a factual issue.
The issue with respect to...
Of whether the doctor found objective manifestations when he last examined the claimant.
Yes, that would be...
On June 10th, did the doctor note that he found pain upon palpation and a decreased range of motion?
I believe he did, Your Honor.
Are those not objective manifestations under our cases?
Those are objective findings.
Why doesn't that end the case?
Because Dr. Taylor also testified on page 27 of the trial transcript. He was asked, Doctor, were there any objective relevant medical findings discovered upon examination of Mr. Morrow after May 12, 2008? His answer was no. Next question. So as of May 12, 2008 and through the present time, there are no objective relevant medical findings.
Except his medical records are to the contrary.
What he found previously.
No, June 10th, 2008. That would have been after May, would it not?
That is precisely the point that I'm trying to make, Your Honor. This is a factual case in addition to being an interpretation of law. And I believe that Dr. Taylor's opinions are quite varied and can be read in several different ways. So I would assert that
Did the JCC not say, not find, in his final order, that Dr. Taylor was unable to ascertain any objective manifestations of injury on his last examination?
The JCC didn't reach that finding, and that is supported by CSC. The portions from the trial transcript that I just read.
Did the JCC address the June 10 medical record?
I can't remember off the top of my head what the JCC said about the June 10 record. And it was confusing, Your Honor, because there were circumstances where Dr. Taylor examined Mr. Morrow. There were circumstances where the nurse practitioner, Mr. Cogdill, examined Mr. Morrow.
But Dr. Taylor examined him last.
Yes.
And he found pain on palpation, which is an objective manifestation, and decreased range of motion, which is also an objective manifestation.
Those would be objective manifestations. But Dr. Taylor also said that as of August 25, 2008, which I believe is the very last evaluation, there were no objective relevant medical findings. And that's what makes this case very difficult, is because there is conflict and there is discongruity between what Dr. Taylor says in his medical records, what the DWC 25 forms say, and what Dr. Taylor testifies to at the final hearing. And there is sufficient conflict in the facts for the judge to have undertake a factual determination and explore the facts of the case and determine exactly what the facts were, which I would assert is squarely and exclusively the province of the judge of compensation claims.
The August 25 visit, which was the last visit.
Yes, sir.
Dr. Taylor did not see the claimant, did he?
He did not.
The nurse saw him.
That's correct.
So the last time the doctor saw him, he did find objective manifestation.
When Dr. Taylor last saw Mr. Morrow. But Dr. Taylor also testified that he is the medical director of the clinic. The buck stops with him. And it is not the nurse practitioner, but Dr. Taylor himself, who is ultimately deciding what is there and what is not.
And did Dr. Taylor say that he had made the referral because he wanted to determine whether his diagnosis, if you will, was correct?
Dr. Taylor testified that the primary purpose of the referral was based on his office protocol. Dr. Taylor testified that when he has a patient that comes in with repeated complaints of back pain, irrespective of his findings, if they continue to complain of back pain, he sends them down the road to a spinal surgeon, be it an orthopedic surgeon or a neurologic surgeon. Page 33 of the trial transcript, Your Honor's question to Dr. Taylor. So is it accurate to state then that the reason for the referral relates to your office protocol? Answer was yes. Next question, and the reason for the referral is not related to any objective relevant medical findings. Answer, no, not on that date. So
Not on August 25th?
August 25, 2008. Yes. Now, with respect to the objective relevant medical findings requirement set forth in the statute, the claimant premises the argument on the grounds that nobody ever recovers. And somebody can have objective relevant medical findings on one day, but not have them on another, and never have them again as a result of the subject industrial accident. And I believe that that interpretation of the facts based on the medical records and the division forms and the testimony of Dr. Taylor is a reasonable conclusion. That when the referral was made, there were no objective relevant medical findings, and it's questionable as to whether or not there were objective relevant medical findings after the referral to the surgeon was made. In addition to that, Dr. Taylor testified, totally unbeknownst to the parties prior to the final hearing, that since he had last seen Mr. Morrow and written a report, he had received the results from both the thoracic and lumbar MRI scans. Both were negative and normal, again substantiating the JCC's conclusion that there were no objective relevant medical findings supporting the request for referral to a surgeon. The appellant argues that all the claimant needs to do is make one showing of objective relevant medical findings, and after that, he is forever absolved of ever showing objective relevant medical findings as related to the subject industrial accident. The appellee asserts that that is not a standard that the legislature intended to impose upon injured workers. The real danger in the claimant's argument, in the eyes of my client, rests with the result urged by the appellant in this case in conjunction with the case decided by this court on June 3, 2009, Engler versus American Friends of the Hebrew University. And the court said in that opinion, quote, once compensability is established, and EC can no longer contest that the accident is the major contributing cause of the injuries at issue. It can only contest the connection between a claimant's need for specific treatment or benefits and the industrial accident, end quote. Now, what the court was talking about with major contributing cause in the Engler case was determining major contributing cause as compared to the industrial accident, or whether there were pre-existing conditions or injuries that gave rise to a major contributing cause analysis. And the court said in Engler that when you have eliminated the possibility of a pre-existing condition or injury as causing the court to then undertake the major contributing cause analysis. In other words, once major contributing cause is clearly established, the employer carrier can no longer raise the argument of major contributing cause, but only the relationship between the claimed benefits and the industrial accident. So if we take the finding in Engler on that point and we couple it with the results suggested by the claimant, the conclusion would be that a claimant who suffers a compensable accident with no pre-existing or contributing factors can go to his doctor and show objective relevant medical findings on one occasion. And from that point, he never has to show them again in order for the employer carrier to be obliged to provide benefits indefinitely. The claimant has the obligation of showing objective relevant medical findings on an ongoing basis. There is nothing in this.
But the issue here is whether, it seems to me, the referral was medically necessary. And I don't see anything in Chapter 440 that says you have to have objective medical findings to determine whether a referral by a treating physician to a specialist is appropriate. The statute talks about pain unaccompanied by physical manifestations not being compensable.
Yes.
But once you accept an accident as compensable, and we're talking about referrals or other treatment, isn't the issue then whether it's medically necessary?
I believe the issue would be, yes, whether it's medically necessary, but the touchstone of that inquiry is the existence or absence of objective relevant medical
And where
findings.
do you find that in the statutes?
It does not specifically state that in Section 440.09 sub 1, but it does not state the contrary either. The statute does not state that the claimant is entitled.
But there's a completely different statute dealing with care and treatment, isn't there?
Yes, sir.
This is part of the compensability statute.
Correct.
We're not talking about compensability here. We're talking about medical necessity, aren't we?
Yes.
I mean, nobody's disputing that if in fact, at least not at this point, if in fact this person is still injured, the injury is the result of the compensable accident rather than some other cause.
That is not being disputed.
Okay, I don't get the reliance on 440.09.
Because the statute says that the injury, its occupational cause, and resulting manifestations must be established. The resulting manifestations would be objective relevant medical findings connected to the subject industrial accident. And the objective relevant medical findings are a springboard to the requirement of the employer carrier to provide the medical referral.
But if let's say you've got a claimant, you've got an accident that's been accepted as compensable. The claimant's treating with an authorized family practice physician. The family practice physician says, well, I can't tell, this claimant is complaining about an injury that's outside of my real area of expertise. I don't see any physical manifestations, but I think she should see an expert in that area to determine whether, in fact, she has this problem. That's not okay?
I believe that would be outside the purview of the workers' compensation system. If the doctor cannot point to something and say this is reasonably related or connected to this industrial accident, if the doctor cannot find through objective testing or physical examination something that the doctor can point to and say this is connected, however tenuously or remotely, to the subject industrial accident, then according to the reading of 440.09 asserted by my client, that the employer carrier is not then obliged to make that recommendation and make that referral. The legislative intent, the appellee would assert, with respect to the objective relevant medical findings requirement, is that subjective complaints of pain alone, in the absence of something that the doctor can point to and identify and elucidate as objective, does not serve as an avenue by which an injured worker can continue to receive additional medical care and treatment.
Would the claimant here be entitled to continue to treat with Dr. Taylor?
Absolutely.
Okay, let me ask you this then. Let's assume that the claimant says, I want to exercise my one-time right to a change of physician, and I want to change to an orthopedic surgeon.
I believe the statute precludes that. I
Why?
believe I don't know the citation off the top of my head, Judge, but I believe something in 440.13 says that the claimant's right to a one-time change is limited to a physician within that specialty.
But if it's a family practice doctor, that's not a specialty.
Family practice could be deemed a specialty. There is a board certification for family practice medicine. One other point I wanted to make, Your Honor, was that there was absolutely nothing in this case to prohibit Mr. Morrow or Dr. Taylor from saying, on this office visit, there are objective relevant medical findings substantiating the need for the referral to a spinal surgeon of one kind or another. But the analysis in this case was limited to that one-time referral. Dr. Taylor never reiterated the referral, never said conclusively, I would assert, that there were objective relevant medical findings subsequent to that operative office visit that then substantiated the need for referral to the spinal surgeon. The danger in the results suggested by the claimant is that medical care and treatment would never come to an end. There would be lifelong entitlement to medical care and treatment wholly in the absence of objective relevant medical findings if the doctor can never point to objective relevant medical findings substantiating the need for the referral. And I see that my time is up. Thank you.
I'd just like to respond to a few things Mr. Vecchio has said. Dr. Taylor did testify on page 27 of the record that there were no objective relevant medical findings after May 22, but then on the pages leading after that up to 31, he corrected himself and said, yes, there were objective relevant medical findings on June 10th. So he did, he did say that, but he corrected it, and his records are supportive of that.
Did he also say that as a result of the August visit, where he didn't actually see your client, he concluded there were no longer any objective medical findings?
He just said that there were none noted that day, but he steadfastly maintained that this man still needed to have an orthopedic evaluation.
So in his deposition, he said, I think he still needs an orthopedic examination?
Yes. I just want to mention that the Angler decision that Mr. Vecchio talked about, I was unaware of that. I don't think that it was cited in the briefs. I think you just said it was a June case. So if it was supplemental authority, I haven't had a chance to respond to that, and I would like a chance to respond to that after. I think that I really think it's important to focus in on this case that there are other defenses that might have been available in this case, but the EC in this case, as I said earlier, put all their eggs in the objective relevant medical findings basket. That's all they did. They didn't say this referral is a major contributing cause. They might have been able to say, if they had been timely in their response to the referral, that it wasn't medically necessary, and maybe they could have raised a defense in that way. But they waived that, number one, by accepting this case as compensable, and number two, they waived it by failing to make a timely response to the referral. And this referral was made actually 3 times. It was made not only on April 22, it was also made on June 10th, and there was a letter that was sent to the doctor's office on May 30th, and I think Nurse Coggle then said, this guy needs an evaluation. So there was 3 times that this referral was made, and there was a late response to the first one and no response at all to the other 2. So it's been made and not responded to. I think that it's really important to also look at the inconsistency of the employer's argument in this case. They accepted this Mr. Morrow's injury as compensable. That's under 440.09, sub 1. One of the elements of that proof is objective relevant medical findings. By accepting him as compensable, this injury is compensable, they necessarily had to agree that he had these findings. And now they're arguing that there's no objective relevant medical findings. And that's...
Ms. LaQuesto, surely you're not suggesting that once an injury is accepted as compensable, that they can no longer challenge or never challenge the continued compensability of certain benefits that are requested, and at the same time require that before those benefits are paid, there must be some objective medical evidence.
I'm not saying that there's no defenses along the line.
Let's assume they accept a back injury in this case, and a year later your client starts complaining about his knee. There's no objective medical evidence to support the proposition that his knee is hurt in any way. You're not arguing that they couldn't deny compensation for the knee on the basis that there's no objective medical evidence.
I think that that's a major contributing cause argument, is what that is. I think that
Well, it could be a major contributing cause argument, but couldn't it also be a no objective medical evidence argument?
I guess it's a new injury at that point. You're saying it's a new injury, and then if you're going to make if he's claiming is now saying my knee hurts, it's a new injury, then you're talking about compensability of
let's say he's claiming
that.
because he had to change his gait because he hurt his spine, he's now developed a knee problem. We've seen lots of those kinds of cases. There's no objective medical evidence of any knee problem.
That's a manifestation then at that argument, and that does fall under 091. It says the injury, its occupational cause, or any manifestation is what they're saying.
They could still challenge that injury even though they had accepted the accident as compensable.
They could, because then it's a manifestation and it comes under the statute. But their argument here, as I pointed out in my reply brief, is that the referral is a manifestation, and that's just not supported by the definition of referral. So I think that kind of hits everything that I jotted down. Unless you have any other questions, I simply ask you to reverse and remand with directions to grant the orthopedic evaluation as per Dr. Taylor. Thank you so much.
There being no further cases in front of the court will